I mean, I've talked to any number of young lawyers, and they'll say sometimes, well, I don't think I'm being paid enough. I didn't think I was being paid enough either when I was a W-2 employee. I don't get enough opportunities. I don't do this and I don't do that. And some part of it you can say might be the boss. It's quite conceivable. I'm not suggesting otherwise. But at some point in time, what you have to do is you have to own it. You have to own what you want to be. If you want to be a trial lawyer, you just have to go and do it. I don't think for some people you can do it going and working for another firm. You got to do it on your own. You got to learn it that way. You're going to, make mistakes. The law is probably one of the hardest professions in the world because it's only after the decision is made to do something some way that you know whether it was the right decision or the wrong decision. And you're never going to know it ahead. You just have to make that decision and move forward.
Howdy, and welcome to the show. Cooper's Code focuses on legal issues and notable practitioners, distilling wisdom so we all achieve the best results for our clients. I'm Miles Cooper, and I'm thrilled to share part 2 of this conversation with Gretchen Nelson. When you first got into writing and how it might overlap with lawyering?
There wasn't a day from when I was born that I didn't want a horse. If you have kids, particularly girls, you have a passion for horses and you're born with it. You either have it or you don't have it. So I probably started writing when I was in high school, not a lot. And then I got to college and they had a really good writing program at the college I went to. So I rode there a lot and moved to New York, and I rode with a guy there by the name of Harry Dallaire, who there's a movie out now called The $87 Horse. He was a really, really amazing rider. He came over from Hungary or something during World War II or after World War II and bought this horse for $87. And ultimately that horse became one of the most famous horses on the circuit, basically jumping. So, I've just always loved it. So I moved to LA, and a friend of mine, Shauna Weeks, now Shauna Avrith, who works actually with Walioka. She was working at Gibson, Dunn and Crutcher, and she had started law school. We'd met writing, and then she started law school probably in 84, 85 or something like that. So this was after I met her, and I was already a lawyer. And she's the funniest person in the world. She was riding ponying horses at the track at Santa Anita at 4 a.m. and then going to work at Gibson, Dunn and Crutcher as a lawyer. So she tries a case in front of a wonderful judge, Vic Chavez, who was a member of the Cowboy Lawyers. Vic died tragically just a couple of years ago, but he was an amazing judge. And they were trying a horse case had to do with a stallion. They were transporting him to Australia in their summer season. Basically, it was just a breeding issue, whatever. And Vic says to Shauna, "Boy, have you heard about the Cowboy Lawyers? You should join." And so Shauna goes on a ride and thought it was really great. She called me and she said, "You have to go." So I went. And I had so much fun. And the people there were so great. There were all these wonderful lawyers from all walks of life, criminal defense lawyers, Jim Nichols, who was probably one of the greatest med mal defense lawyers in LA, Jack Denovi, Bob Ludi. I don't want to forget anybody, Wilkie Chung. The list went on, and we just had the best of times. And all you do is you ride. You go out, not supposed to talk politics, not supposed to talk law. What you're supposed to do is go out and have fun. And the only people we kick out or don't allow in are people who are horrible to their horses, or the one guy who hit on a female judge. And we decided he wasn't going to make it either.
Where would you ride in Los Angeles?
In LA, there's a ton of places, but we do 2 or 3 overnight rides during the year. And we've ridden in Tahoe 2 or 3 times. We've ridden in Point Reyes out here in Marin County. We've gone as far south as Cuyamaca, which is down below San Diego, kind of around Julian in that area. We've gone out to Palm Springs. There's a ton of places. And then in LA, locally, there's any number of state parks, national parks that California has a very robust park system, both countywide and statewide for riding. I guess probably its historical background as being, horses were an integral part of it. In Burbank, I don't know if you know Burbank area very well, but there's a whole equestrian area in Burbank where everyone's house has some sort of small paddock in the background, and you keep your horse right there. So Griffith Park is a great place to ride. We've ridden there a number of times, but it's great. It's wonderful. It's really the friendship as much as anything, and being out with your horse and just enjoying it. So
I'm not bringing this up just for the interest of the Cowboy Lawyers Association. I also have some questions as it relates to whether your work with horses has impacted your work in terms of the courtroom or other places. And here's the genesis of my question. I've not done a lot with horses, but my longtime mentor, Cynthia McGuinn, did a lot in natural horsemanship and would take me out and have me work with her horses in terms of the energy that one projects and how a horse as a prey animal, is very responsive to that. Have you found in your work with horses that you've learned more about yourself, the way you engage with jurors, the way you engage with opposing counsel? Has that been something that's been useful in your career?
Yeah, I think so. I mean, I think you raise a very important issue on a lot of different levels. So you're right. Horses are prey animals, and they're very reactive. They're very reactive not only to physical touch, but to movement that is either somebody on them or somebody around them. And I think there's a lot to be learned from watching, and that's what a horse is always doing. They're watching and they're hearing. They're not talking to you, except they're expressing themselves through other means. So you have to learn how to communicate without talking. And I think you do learn a huge amount about not only yourself, but I think you learn an enormous amount about other people. And some of it is, people react differently than a horse, but in many respects, they act the same. There's simple ways you can look at it. A horse, when they become very nervous, they tighten their mouth, tighten their lips, and they are not paying attention. And you can tell they're not paying attention because they're now in kind of flight mode. A juror can do the same thing. You'll see them tighten their mouth. You'll see them look away. You'll see them, and if you're reading it right, you're reading they're not reacting to you. To be able to stop that, to break it, you have to then do something to get the horse re-engaged with you. You have to do something to make the juror re-engage with you. And quite frankly, I think so much of it isn't the words you're using so much as the cadence of your speech, the tone of your voice, how you are standing, how you are physically present. Because those are the things that a horse reacts to. It's the same with a dog. I mean, it can be, I don't mean to say that horses are the only ones you can learn this from. I think you learn it from dogs. I think you learn it from any animal that is not communicating with you by voice. And a juror never is communicating to you by voice because they can't. They can write a note and they can send the note to the judge, and the judge can decide whether he or she's going to ask it. But you can only read them by what they are physically doing. And I think if you take what you learn from working with some kind of animal any animal really. For me, it's horses and dogs, but it could be a cat, although I'm not a big cat fan, although I am a dogless woman. Or what was that line? What was that crazy line?
Childless
cat ladies.
Yes.
Okay, I'm a childless dog lady. I knew I was going to say that wrong.
It's okay. You might be weird.
So I think if you watch them and you pay attention to them, you can learn so much from it, including how you just talk to them. If you go up to, I've gone up to a horse with a kind of sour look on my face, and that horse has a completely different reaction to when I go up to the horse with a smile or with a very relaxed face. So you can't be upset if you are trying to communicate with them. And you can't be upset if you're trying to communicate with a jury. You have to be calm, and you have to be watching them and understanding where you're going. And I personally think your voice sometimes just has so much to do with it.
And I was going to follow that line a little bit, which is if you see a juror, sense a juror that is doing that tightening and that turning away, what specific types of actions might you take in terms of trying to unwind that flight mode for a juror?
I mean, it's happened to me. I will say the time it happened to me that was the worst, that I never really did do it very well, was a case where I was handling all of these crazy experts on a crazy case that the science was so wacky. And I was very uncomfortable, and I wasn't able to really do it very well. I finally did it on like the last expert. I finally got the sense of how to question him. And, but in other cases, I have done it. I've realized, as you see it happening, that I was getting a little strident. I was getting in the face of somebody. And, a little bit of this to me is who your personality is. So there can be one lawyer who can be really strident and be in someone's face. And that's okay for a juror, because they may sense that's who that person is. They may not like it, but they may appreciate it in that. It doesn't work for me. I just have to be a little bit more relaxed and more at ease with myself. Because if I'm not at ease with myself, then it becomes strident, and then it doesn't work. But again, I think it's very hard for me to put this into words. And I think it's different for every person. I mean, what works for me may not work for you. What works for, another Chris Spagnoli may not work for me. I mean, Chris is somebody who is really, really excellent at just focusing and nailing either an expert or a witness on an issue. And that isn't me. I have to do it I have to go about it in a rounder way, if that makes sense.
It does. And I think the commonality that I'm hearing is that you need to find your style and be comfortable in your skin. And if you start acting out beyond that, that's when that disconnect occurs.
Yes, absolutely. It's so funny to me how you can see it. They get it. If you're acting, they know you're acting, and they're not going to pay any attention to it. You're just acting. If you're true to yourself, they believe you then, because then you believe it. I think there's a real, that to me, for young lawyers, if I've learned anything in the 40 years I've been doing that, I finally learned that. It took me a while, and it was hard because I kept always thinking, oh, let me do it the way that person did it. Maybe I should do it this way. And finally I realized, why don't you just do it the way you are? And that's when it worked.
So going back to the 4 years in the deep end, how many trials, how many depositions, how many engagements was it within that 4-year period, or was it, a decade or more before you really found that who you were in the profession?
Oh, it was well after that. I didn't find myself in that first 4 years. I was, it's a different time. There's so many wonderful young women lawyers now. It's just so great. And they're getting all this good opportunity. I don't think when I was in the 4 years I was at Morgan and Wenzel McNichols, I don't think I was in front of a female judge once. I mean, every judge was a male, mostly older white males. Not that I have anything against older white males. I'm just saying that was just the demographic that you had. We didn't go to trial much at Kornblit and Seltzer for not surprising reasons. There are always, huge cases and they generally settle. And then I went on my own in 1998, which was really one of the best things I did. And I started getting very involved in bar organizations. I, sometime around there, started doing some work with the Cala Board. I was on the LA County Bar litigation section. I forced myself to do a lot of speaking. I became much more comfortable at it. I realized that sometimes people like listening to me. And I began to wonder what was I doing so I sort of analyzed myself. But in the 4 years I was on my own, I had to do it all. And I loved it. It was actually 5 years, 98 to 2003. And that was one of the greatest times I ever had. I learned so much about myself. I probably wasn't 100% successful on the monetary end of it, but I was way successful on the emotional and the professional end of it.
If you were to pass on to others that 4 to 5 year period where you were on your own, what things did you learn about yourself? What things would you encourage people to do in terms of going out on their own?
That you can do it. That's what you learn. You get a W-2 employee sort of becomes a W-2 employee. And you're always sitting there, not necessarily complaining, but, you're always thinking, oh, they should do it this way, or, oh, they should do it that way, or how come I'm not getting this, or how come I'm not being paid that? You go on your own, you have to do it all. I mean, it's, soup to nuts. I was a solo. I was, doing the accounting, doing the, and then trying the cases and, taking them on, having to find the clients, having to run a business. And when you do it, you all of a sudden say, oh, I can do that. And if you just stay a W-2 employee, I mean, I've talked to any number of young lawyers and they'll say sometimes, well, I don't think I'm being paid enough. I didn't think I was being paid enough either when I was a W-2 employee. I don't get enough opportunities. I don't do this and I don't do that. And some part of it you can say might be the boss. It's quite conceivable. I'm not suggesting otherwise. But at some point in time, what you have to do is you have to own it. You have to own what you want to be. If you want to be a trial lawyer, you just have to go and do it. And doing it, and I don't think for some people you can do it going and working for another firm. You got to do it on your own. You got to learn it that way. You're going to, make mistakes. The law is probably one of the hardest professions in the world because it's only after the decision is made to do something some way that you know whether it was the right decision or the wrong decision. And you're never going to know it ahead. You just have to make that decision and move forward. So my recommendation would be go try it. And the meaning can be for two things.
Yeah. If you're enjoying what we're doing here with Cooper's Code, please extend our reach by giving us a 5-star review on Apple Podcasts and consider sharing an episode with a friend. Additionally, we want to know who you want to hear on the show. Have an interview suggestion? Email us at podcast@coopers.law. I keep wanting to come back to securities, but I feel that I don't want to overlook something that you brought up, and that's being a young woman in front of old white men judges. Yeah. I know it's been 4 decades that you've been in practice, and I imagine things are different now, hopefully somewhat, than they were then. What tools did you have to employ to deal with a different world at that time?
Oh gosh, you're taking us all back in time now. It was completely different. I mean, there have been changes in people's understanding of in that 40 years that have they're light years apart. The women's movement had really just sort of begun. It was not in its infancy, but it was in the 60s that women began to feel more, I'll use the word liberated. That was the word we used. The 70s, there was still growth in that area. And the 80s, there was still growth, but it really then, I would say, in between 2005 and where we are now, in the last 20 years, there's just been these massive leaps. There are things that were totally acceptable back then, which shouldn't have been, but they are completely unacceptable now. So you kind of just go back, and you can't change what happened back then. You can just say, I learned from it. I always found, and maybe it was just me, my personality and my who I was, who I looked like, or whatever. I always used to kind of laugh it off. I mean, there will be comments made and you just roll your eyes like, oh my God. And you just move on. And there are wonderful other women lawyers back then. Edith Mathai, Lee Edmond. I mean, there's a whole slew of them, many of them now on the bench. Donna Melby. I mean, you can go through the litany of them. They're all great trial lawyers. And we could all sit down together and we'll all laugh and say the same thing. I personally felt you couldn't get angry. If you got angry, it wasn't going to help. Then you'd just be stuck being angry.
So I have a question for you.
Yeah.
We've really just met and had a fairly short interaction.
Right.
You don't strike me as the type of person who gets angry. You seem to have a kind of a calm tenor to the way in which you engage. First, I may be wildly off on that, but to the extent that that's correct in any way, is that something that's just natural to you? Perhaps decades of having to worry about how you engage?
When I was younger, I wasn't this way. That's a lot of age bringing some measure of hopefully wisdom, I guess. I don't know. I have to say I wasn't really great on the defense side. So it was harder for me as a defense lawyer, mainly because I always wanted to be on the plaintiff side. I'd be looking at these cases going, why don't I have that case? Why do I have this case? So when I became a plaintiff's lawyer, I found that I was much more relaxed. I would still get nervous, obviously, who doesn't? I would still worry. But I was much happier, let's put it that way, representing the plaintiff. And I don't want to be dismissive of people who represent defendants because they are phenomenal lawyers, and I so admire what they do. That's just, to me, a thing that's personal to you. It's not judgmental. I'm not trying to say that, defense lawyers are one way and plaintiffs lawyers are another way. I think it's just within me personally, I found myself more comfortable as being a plaintiff's lawyer. And I think that helped a lot. The defendant has the checkbook. So nobody wants to give money to somebody they hate.
Yeah. So
there's an element of this that you just sort of realize, okay, maybe I need to back off a little bit. I mean, I can get my back up. That can happen. But I do have found as I've gotten older, I've just kind of calmed down a lot more.
I've said a few times that I want to get to securities. And part of the reason I want to get to those is because you are our first guest who has done that kind of work. And I think a lot of our listeners are more knuckle dragging, personal injury, either plaintiff or defense side. I'd love to hear a little bit about what that kind of work looks like as you describe the work that you did in that.
So first off, it's changed dramatically, as probably everything in life has. But when we started out, I started at Kornblatt and Seltzer. That was before the PSLRA, which is the Private Securities Litigation Reform Act, which was signed by Bill Clinton in, 1997 or 98, which really changed the landscape. it was a couple points. It's a very collegial, small group, certainly early on, and now probably still so. Very heavy research and writing intensive. You can bank on motions to dismiss. You could bank on motions to dismiss back then. You had to accept that you were going to be in for the long haul. There's layers of this case, like any case. There's the layer that's the liability part of it. There's the layer that's the damage part of it. And then there's the layer that's the insurance part, which of course is a little more complicated in a fraud case, which is what securities fraud is. So you're always saying it in two words. It's either they negligently misrepresented it or they intentionally misrepresented it. And there's a very strong reason for that, which is you don't want to buy yourself out of the insurance policy.
Is there usually some form of coverage for these?
Oh, yeah. Directors and officers liability coverage, for sure.
And is this all federal work?
Yes and no. Certainly back when I started out in it in 1988, there were state cases. If you're filing under certain of the federal statutes, it's original jurisdiction in federal court and sole jurisdiction. There are some securities claims that can be brought in state court. There are state claims that can be brought, but that's a whole another issue that gets you into another change in the law, which is that they created CAFA, which is the Class Action Fairness Act. So in many respects, today, if you have a securities fraud case, you are stuck in federal court. Or if you have a case that is an arbitration case, like a broker-dealer case, then you're in arbitration.
And is that like a FINRA arbitration? Or
Yeah.
And within the panoply, the umbrella of securities work, is FINRA something that your firm did?
Yes, we did. We didn't do a lot of FINRA work, but we did some. And we'd still do some. Gabe Barenfeld, one of my partners, has done a fair number of those cases. And they're nice, interesting cases. I mean, you can really get your teeth into them. And I think the arbitrators like them too. They're interesting cases. It is certainly true that in the securities class action arena, the sort of big umbrella arena, the work is fascinating and the law is all over the map. And what I used to write these articles, everybody used to laugh at me and say, "Oh my God, Gretchen, why are you doing that one again?" They're the only class actions I've always thought the Supreme Court likes. And I always assumed it was because they probably have stock.
Interesting.
So you could see where there'd be all these efforts made and you go all the way up to the U.S. Supreme Court and the defendants were so excited about potentially getting, some good law from the U.S. Supreme Court. And it was like, right? Doesn't help them. So they're, interesting cases that go to the Supreme Court. The law, when the PSLRA changed, it used to be all you needed was anybody who bought stock, right? You could get your neighbor who comes over and complains and says, "Oh my God, I bought this stock and the price just tanked." And then there would be a fight over, who's going to be lead counsel. And then the PSLRA changed all that, and it made it changed the landscape. The landscape became basically the plaintiffs were the largest loser was the presumptive lead, and that was largely pension companies. So there's a smaller group of firms now that really work in the area because they develop relationships with pension funds.
And do the pension funds do this on contingency, or do they? Okay.
Mm-hmm. Yeah. Yeah, I mean, I suppose it depends on how they've worked it out, but most of them, I'm assuming now, it's still contingent. I mean, it's a race to get a resolution of it that's favorable, and then they're usually done as a common benefit fund case where everybody gets whatever their proportionate share is based on their damages. I mean, the thing that, going back to what I was saying, is that, you've got this layer of it. So the first layer is liability, which is huge. First you got to prove that they knew or just kind of kept a blind eye to the fact that, they really weren't selling any of those widgets. Or as the ZZ Best guy was doing, he was taking accountants up to buildings and saying, I have a $10 million contract to refurbish this building because it was burned in a fire. And it turned out it was a building under construction, and he just paid somebody off to take the accountants in there, and there was no contract. So, you've got from that panoply to, we fudged a little bit on this because we thought we were going to get these contracts. So you got to prove that part of it. Then you got to get a class certified. That can be a difficult issue. And then you got to get the damages done. And that can be that's so expert intensive, it's not to be believed. And, and every little bit, the defense lawyers are fabulous in the area. I mean, they're always picking at you, right? They're piecing this one, they're going after you on this one, and causation on this, what? So you're constantly parrying them. And there's a wonderful excitement about that when you find an edge to get around an argument. And the judges are fascinated by them. They like the cases. They find them to be, the quality of the lawyering is very good. And, so they're cases that when you go into court, the judge is keen on hearing from you. And they're even in the state court. So in state court, you can have to me, if you've got an opt-out, say you've got an individual and you have a claim that's based on something that has occurred, you can stay, if you can, in state court, and then you're pretty good off, but you're just basing it on state claims, fraud, negligence, whatever. They're fun. I like them. It was a good time. We had a good gig. I haven't done a lot. I mean, I really haven't done much of it at all since the law changed, because I'm not, I just sued CalPERS. I'm not trying to represent them. So
when you say you just sued CalPERS, I know from reading your bio that nowadays, at least according to your bio, you're working primarily on complex class actions, business torts, and some cruise ship and maritime incidents. So when you say you just sued CalPERS, what kind of an environment are you pursuing something like that?
Well, it's a great case. It was an insurance case. It's long-term insurance based on, telling people they're going to raise their premiums and then raising their premiums. Yeah, no, that was it. We started it in 2013. It was a great group. We're still doing it. I mean, it's pretty much settled down, but there's some just the, leftover stuff going on. But although there was one piece that we're on appeal on, but it was Mike Bedard, Greg Bentley, and Stu Talley from up in Sacramento. And we filed this lawsuit in 2013, and we were in state court and have had wonderful judges and just kept, pushing and pushing and pushing, and finally went to trial on the last judge, Judge Heiberger, phased the trial. So we had the first two phases, and then we wound up resolving the case. But it was essentially a breach of contract case, but on a huge level. And, very compelling. Our clients were wonderful, wonderful people. And all the class members these are all retired or soon to be retired state government, local government people who were sold these policies back in the 90s. And the long-term care industry is really quite a fascinating, just to dip your toes into that and to learn how this whole thing has unfolded is kind of interesting to me. And so
I'd love to hear a little bit more on that.
Well, so they started selling long-term care policies back in the 70s, right? And they really started selling them in the 90s. I think in part, there's people who have also talked about this, that, governments began to think, whoa, we got a lot of baby boomers out there. And Medicare doesn't pay for long-term care. And Alzheimer's began to become much more, probably wasn't more apparent, but certainly more talked about. So in the 90s, late 80s and the 90s, they really started selling them like crazy. And they're an interesting policy because the insurance industry, I think, was looking at them, trying to compare them really to a life insurance policy. So you start selling these things and, the carrier's taking a risk, right? You're basically saying, I'm going to pay you money every month for this policy, and I'm going to for long-term care, you kind of hope you never do have to use it, right? But then you hope if you do need it, that it's there. And if the policy gets too expensive, you're trying to decide what to do. Let's take the life insurance policy. Policy gets too expensive. The only person who benefits from the life insurance policy is your family or your relatives or somebody, whoever you have as the beneficiary. And so you're going to be dead. So what do you care? Long-term care, on the other hand, is you. I need it. And, maybe my kid or my spouse won't be able to take care of me. So I'd like to make sure somebody will. And so you don't lapse it as much if the policy gets too high. You may drop down, reduce the benefits in some way, either the length of time or the amount of benefits, amount of money you get per day or whatever. So the insurance company, when they were pricing these things, I think back in the early days, really kind of messed up because they were assuming a lapse rate that would be equivalent to a life insurance policy. There are morbidity issues and mortality issues that they're looking at. And obviously, the other aspect of this is people are living longer. So these policies are being sold, and then all of a sudden there are these whopping huge increases. I mean, we're not talking 10% or 20%. We're talking 85%, 165%. And now you've been paying, let's say you paid in $60,000 on the policy. They raise your premium and you're stuck trying to decide, do I pitch all that away? Because if you drop the policy, they keep it, you leave. And then you don't have a policy. And it usually occurs at the point in time when the person is on a fixed income, they've been retired, or worse, their health has become such that they'll never find another policy, or that are at an age that no carrier will write them. So the policyholders are placed in this just untenable position. And it's a fascinating history. I mean, there's been numbers of articles in the New York Times, Wall Street Journal, Fortune. I mean, tons of articles written on it, as well as a lot of treatises and stuff. So anyway, it's been a cool case.
It sounds like important work.
Yeah, I think so.
Yeah.
We had a great time. I mean, we tried Mike Bedard and Greg Bentley and Stu and I went to trial in the first two phases of this. And I mean, it was kind of a limited issue that was kind of contract interpretation issue for the first two and a statute of limitations issue. But we had a hell of a good time trying it. So
thank you for listening. And please join us next week as we continue this conversation. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions for who we should have on the show. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.